So good afternoon. Welcome. Thank you so much for joining us. I think a few more folks might be coming in slowly, but we'll get started since it's 12:01. I'm Reedy Mukopade. I'm with the Sexual Violence Law Center. My colleague, Sarah Mooney, who is our pro bono counsel, couldn't make today's session. So you're going to be listening to my very soothing and engaging voice for the next hour. We usually have a slide about SVLC, but I'm going to cover so much today. We're going to skip that. But for anybody who's new to our monthly trainings, very briefly, we're a nonprofit law firm that works with survivors throughout the state on cases related to sexual assault, domestic violence, stalking, and gender-based violence. And our services were holistic, meaning we work to address all the legal issues related to the abuse the survivor is experiencing. So that means working with them on their protection order, housing, Title IX, immigration, and more. We're also available to provide technical assistance and resources to any advocate or attorney who is working with the survivor. And our contact information is going to be at the end of this PowerPoint, which you will be receiving next week, along with part 1 of the training that we did in April. So before I jump into the full presentation for today, I just want to give credit to retired Judge Ann Levinson, who has created sort of the master template on this training, and we've taken it and adapted it more geared towards advocates and attorneys. But last session, where we covered the first part of the protection order statute, which goes into effect July 1st, we covered legislative intent, definitions, jurisdiction and venue, filing, service, including e-service, hearings, remedies, durations, and effective dates. And for today, we're covering a little bit more about hearings. We're covering the surrender of weapons and ERPOs, the weapon surrender and ERPOs. We're going to talk about reissuances, renewals and terminations, violations, enforcement. Actually, the termination should have been with modification. Violations, enforcement, modifications, and touch on judicial training. So for any of you who've attended our past CLEs, we do try to make it more interactive and answer questions as we go along. In this case, because I'm covering so much, I won't be necessarily responding to questions. I'm also very bad at trying to handle the PowerPoint and Zoom and post things in chat. So it's just easier if you post your questions. If folks know, please chime in, provide a response. We are going to be tracking the questions, and along with sending out the PowerPoints and the recordings, we're going to also try to address all the questions with the FAQ in the follow-up email. We aren't going back through the materials from the last training, but I did want to touch on the legislative intent again, because I think it so clearly articulates the purpose of why RCW 7105, which is the combination of the last of Washington's 6 protection order statutes, why it was so necessary to have one comprehensive protection order statute under one chapter. And there are so many reasons, but some of the bigger takeaways from the legislative intent is the new statute really allows for victims to access safety without having to rely on the criminal legal system. It's really focused on improving the surrender of firearms to reduce harm. It's worked towards harmonizing and clarifying and simplifying the civil protection order process and statute. It incorporates a lot of technology advancements that became available to us during the pandemic and now makes them more permanent. And it's just much more efficient. We know, any of us who work with pro se litigants know that sometimes it's very confusing for them to know, should they be getting a sexual assault protection order or a stalking protection order or a DV protection order, depending on the type of abuse or abuses they're experiencing or the relationship. And by having it under one chapter, hopefully we can now allow for greater access. Also, just a very quick summary of the two bills that passed that are now 701 from the 2021 session, HB 1320, which really focused on combining and reconciling the differences between the protection orders and making sure that they're more consistent. So many of you, I saw some names, like I saw Bill's name on here. I saw Bill, you're on here, who worked on the Smith v. Smith case. There's Maldonado. There's so many other great case law that we really wanted to make sure got incorporated and codified into the new statute. So that was another thing 1320 focused on. It addresses the use of technology to allow for remote hearings, allow for electronic service, in a way that previous protection orders never did. And again, hoping that that allows for greater access to justice and access to safety for survivors, and reduces burdens on litigants. This last legislative session was a follow-up to 1320 with HB 1901, which really went back and looked at jurisdiction. It standardized transfer processes between district and superior court. One thing we looked at in April is the addition of course of control to the definition of DV, which is exciting for any of you who work with DV survivors, because we know that before the physical assault, the sexual assault, that there's a pattern of control that a lot of survivors experience: financial control, emotional, psychological control, social isolation. That course of control now addresses. It modifies services, how to serve and hearing issues, and then it further standardizes relief and violations, responses to violations. The other thing that the statute really does, it provides for statewide best practices for protection order proceedings, which we know are special proceedings, and hopefully makes it less complex than traditional criminal and civil proceedings that the courts are more used to. So we had talked about hearings previously. Again, I'm not going to go back into what we already covered, so I'm just going to jump into what we didn't cover last time. And for hearings, one thing we wanted to highlight that the statute now does is that it makes it clear that a respondent's appearance at a proceeding constitutes notice. So many of us have experienced the situation in court where service didn't occur, or there's no proof of service, and then the respondent shows up. And sometimes, depending on the court you were in, that was not sufficient to say that the respondent was now accepting service in court. And sometimes we would still end up on that merry-go-round or that roller coaster where the court would then require separate service even after the respondent would leave. Another aspect of the hearing that's I think very exciting is that the court now has the discretion to appoint counsel where the respondent, for the petitioner, where the respondent is represented by counsel. This was something that was previously only in the Sexual Assault Protection Order Statute 790, but now by consolidating, this option has now become available in DVPOs and stalking orders and all the other protections that are under 7105. It is at the discretion of the court, and regarding appointment of counsel, it really is about sort of the availability of funding or programs that the court has access to. So there's no guarantee that the petitioner will actually get counsel appointed, but it does allow for the opportunity if there are pro bono programs in the community, if there's legal aid programs like ours or NJP or some of the volunteer lawyer programs, or if there's funding to potentially have a panel of attorneys who may be appointed. So this is something that I think many advocates and survivors will be excited about, and something as attorneys that we should be paying attention to in case the courts do reach out to us. Also, before ruling on a protection order, this was also something that was in some of the statutes. Courts need to be checking the JIS system to check for criminal history, history of the respondent and the petitioner related to past protection order proceedings, and any other legal proceedings that involve the parties. So before the ruling on protection orders, that only existed in the stalking protection order and anti-harassment to determine criminal history. And this now builds on the provisions existing from that protection order and making it more consistent throughout. Also note that tribal orders are being addressed with 1901, and will also be something that the courts will be having access to. Tribal courts should get access to Washington court orders, and Washington state court orders should be getting access to tribal court orders here in Washington. What else? Yes. The other thing is the courts must take judicial notice of parallel criminal proceedings related to if it involves conduct involving the same parties, including whether or not the defendant is waiving speedy trial. We know so often in civil protection order proceedings, sometimes the petitioners are made to feel like they're being held hostage in the civil process because of the criminal proceeding, where the court keeps continuing the protection order case just to see what's happening. So there's clear requirements around what the court should be considering and the factors, which we'll talk about more. Just looking at my notes to see if there's anything else here. We'll go into the next one. So a court's ruling related to hearings, a court's ruling on a protection order has to be filed. This is ex parte, temporary, and full, must be filed by the court in writing and must be made by the court, or on mandatory forms that are being developed by AOC. So the Pattern Forms Committee has been really hard at work. I'm involved in the drafting of these forms, so I have not been as diligent as some of my colleagues have been, who have been meeting on a weekly basis to try to get the pattern forms updated based on the new statute. And I believe they should all be available before the end of the year, along with brochures and resources that can also be helpful to pro se litigants and any advocates and attorneys working with survivors filling out petitions under 7105. A delay in the entry of the full order by granting continuances and renewing the temporary protection order can also really delay firearm risks. So the court also needs to really be making sure that firearms relinquishments are also being included in the temporary order. So this is related to compliance hearings for respondents, where there's now language that it strengthens the compliance requirements for protection orders involving orders to surrender and prohibit weapons. So regarding court's ruling that it must be filed, the order must be filed in writing, it must be made available on mandatory forms developed by AOC. This provision was not something that was explicit in past statutes, which is why we often saw from county to county, sometimes courts would have their own protection order forms, which can be very problematic and inconsistent in enforcement. And this is one reason why there was a concerted effort to make sure that there's language about mandatory forms and making sure the courts are using the same forms consistently. Another aspect related to the hearings is thinking about certain third parties that often are involved. One is working with interpreters. So many of us, especially in civil legal aid, work with litigants whose English is limited and are needing access to interpreters and needing consistent access to interpreters. So the statute also has some very explicit language about the expectation of working with interpreters. And some of these were best practices recommended by the Supreme Court's Interpreter Commission. That includes that the court must appoint a credentialed or qualified interpreter, and that an advocate for a party cannot be appointed as an interpreter by the court. We would often see where some courts would not take the steps to appoint an interpreter, and they would just have whoever was there with the petitioner interpret for the petitioner, and that also causes problems for the record. And parties should have access to appropriate professional interpreters through the proceedings. Also related to interpreters, once an interpreter is appointed for a party, the party is no longer required to continue requesting an interpreter, which we had also seen in a lot of cases where you ask for an interpreter for the first time, you go to court, next time the interpreter's there, and then maybe the case gets continued and you go back to court and the interpreter is no longer in the hearing because apparently the petitioner had to continue requesting an interpreter. And we know how problematic that is and how difficult that is for pro se litigants. And so now the statute really puts the burden on the clerk's office or the court administrator to identify and ensure that interpreters are consistently available in subsequent hearings once appointed. When a hearing is conducted through telephone, through video, or electronic means, or essentially if the hearing is remote, the court needs to be making appropriate accommodations to permit interpreters to be able to really serve the party and assist the party as needed based on interpretation. Another thing is making private space available for the parties to be able to meet with interpreters. So often the court will send, I think about when we were in person, the court would send maybe the petitioner out into the hallway to go talk to the interpreter. And instead of being able to quietly talk to the interpreter about, maybe very private information, you're sitting there in a public hallway. And we know in some of these cases, the sort of manipulative, abusive steps respondents take even in the courtroom setting, and maybe the respondent's coming out and kind of like hovering nearby. And so making it very clear that petitioners and anybody who's needing an interpreter have appropriate space made available. I see some stuff popping up on the chat. Okay, thank you for all the excitement about the statute. I'm really excited about all this statute is making available. So I'm hoping folks are really excited as well. Another aspect of interpreters is making sure that the interpreter can interpret in helping a litigant fill out the form where, and this was because so often the interpreters appointed might only be interpreting in court, in the courtroom. And then as soon as you step out of the courtroom, they leave. And then the petitioner or respondent who don't speak English or may not, their English may not be proficient enough to be able to go through the forms are then left standing without any sort of resource. So making sure that the interpreter is also given the appropriate authority to assist with interpretation and translation outside of the courtroom related to forms and translating any orders. The last point related to interpreters I wanted to highlight is the clarification that the same interpreter should not be serving both parties. when not on the record. We sometimes it's possible that you have only one interpreter who speaks that language, and they need to be able to communicate on behalf, interpret on behalf of both parties, because otherwise the case can't move forward. That's very different being on the record in front of the judge versus then being off the record, and then using the interpreter to go back and forth between parties. And so this was also something that was recommended by the Interpreter Commission that is now codified in the statute. And the big reason for this was to ensure that the safety of the litigants are not compromised, or any private information isn't accidentally identified or shared between the litigants. We talked about interpreters. The other sort of third-party consideration in these hearings that I'm also really excited about is the statutory language around advocates. So this expanded on the provisions that authorized advocates to appear with petitioners at all proceedings. So first of all, making it very clear that an advocate for a party may not be appointed to interpret by the court, because we know that many programs, many of the DV and sexual assault programs have bilingual advocates. And when you're interpreting, you cannot advocate and support your client in the same way. So making it very clear that the court really should be focusing on getting credentialed interpreters and allowing advocates to be advocates. Another thing the statute now does, 7105 does, it also, along with advocates, identifies support persons as that a petitioner can have a support person to accompany the petitioner. We know not all jurisdictions necessarily have access to advocacy programs and advocates, but petitioners may still want somebody to be there with them, to be there for emotional support, psychological support when they're in court, and to make sure that they are allowed to have their support person there, and that person is not kicked out solely because they don't have the title advocate. The statute also makes it very clear that the communication between petitioners and sexual assault and DV advocates continue to be protected under the privilege statute, and related to support persons, unless they are employed by the government, that they can't be cross-examined or questioned by the other side. Advocates and support persons are not allowed to provide legal representation or interpretation services. However, in remote hearings, they can confer, whether in remote hearings or in person, they can confer with the petitioner. And the reason for that language is we would often see maybe the petitioner is confused by the question, and then they turn to the advocate just for clarification, or maybe they freeze up, but they had shared information with the advocate. And so making sure that some communication is allowed between the advocate and support person and the petitioner, and because of that communication, that they're not going to get excluded by the court. I'm going to check time because I'm trying to go fast and it's not happening. Okay. So with hearings, when there is a denial, two things that are required of the court related to putting it in writing is if there's a particular reason to decline issuing a protection order, and the court also needs to put in writing if there's a reason the court declines to include children or a vulnerable adult who's a part of the household in a protection. And this is the codification of Maldonado. Another aspect of denials after a hearing is that the court now has an obligation to explain from the bench the petitioner's right to refile for a petition if there's new evidence. So often petitioners, their petition is dismissed and they feel like they can never go back to court, and making it very clear that the court needs to still be open to petitioners when there's new evidence available. or if there's a reason to file a new petition. Also making it very clear to petitioners about revisions, reconsideration, and appealing a decision, because especially with revisions and reconsiderations, it's a 10-day deadline. And often petitioners, pro se litigants, are then trying to figure out, once it's denied, what do they do next? And they may not be aware of that 10-day deadline. And then they lose that opportunity for a reconsideration or revision. So now the court has an obligation to make sure that the petitioner is aware, and also making sure that parties know that they have a right to access the court transcript or recording and how to do so in case they do go forward with the revision, reconsideration, or an appeal. Okay, so the other big part of this statute is sort of the comprehensive protections related to firearms, which we know increase lethality risks in DV cases and stalking cases. I'm discussing firearm surrender and ERPOs related to 7105, but this should be read in conjunction with RCW 941 and 1099, which also address firearm surrenders and violations. So I'm looking at one part of this. I'm only looking at this statute, but just a reminder, there are a few other statutes that are in play when we're looking at firearm surrender. So these are now called order to surrender weapons and prohibit order to surrender and prohibit weapons. That is the OTSW. To better clarify the requirements of the order, and are now authorized for DVPOs, SAPOs, stalking protection orders, anti-harassment protection orders, and VAPOs. For any of you who know the history of firearm surrender, it initially started with DV protection orders and wasn't connected to the other protection orders, but recognizing that firearm access is not only a DV issue, the expansion has been really important. The court shall issue order to surrender weapons upon a showing by a preponderance, which is, I think, a huge improvement, because previously it was a clear, convincing standard. And now that has been shifted to a preponderance standard, which is more aligned with civil protection order proceedings and protection orders in general. RCW 941, which I talked about a second ago, this talks about how the findings must be made, and this is RCW 941-800, talks about how the findings must be made by the court when issuing an order to surrender and prohibit weapons. And RCW 941 something 100, I forget the elements. It talks about the elements for unlawful possession once someone is prohibited from possession. And this now aligns state law with federal law regarding credible threat findings. Before, it was also discretionary. There was the language around the court shall upon showing of clear and convincing evidence. And now, or previously it said court shall, or the court may, and now it's the court shall. The other thing is that the assumption is when there is a DV finding, there's already a finding of credible threat. And so you don't have to have a completely second finding, a secondary finding solely for the weapons surrender. So that also brings the protection order more into alignment with the protective factors and the protective intent of the protection order. Oh yeah, this is exactly what I wanted to identify, which is the court shall issue if there's a finding that the parties represent a credible threat, and there is also the element of considering if there is a protection order that prohibits the use, attempted use, or threatened use of physical force against an intimate partner or child, where there could be reasonable expectation of bodily harm. This is where the court really, there's no discretion. The court shall issue the weapon surrender. And again, so this doesn't require the extra step of a separate credible threat finding that used to be required after a protection order for compliance related to firearms. Existing law required surrenders within 48 hours rather than 24 hours. This changes to help address heightened risk of lethality again when firearms are not relinquished. And for ERPOs, the respondent must immediately surrender all firearms and concealed pistol license not previously surrendered in a safe manner to the control of the local law enforcement agency on the day of the hearing at which the respondent was present, either in person or remotely. Also included, if the court has information regarding any of the respondents' known aliases, that information must be included in the protection order to help ensure proper identification of the restrained party, to help identify potential firearms purchase history, which could also be used under an alias. So these are some other aspects of the statute that really strengthen the firearms surrender, the weapon surrender. And then another aspect of the weapon surrender is 941, which I talked about earlier, is now amended and directs the concealed pistol license to be immediately revoked when a person is ineligible or convicted for a third violation within 5 calendar years. So any law enforcement agency can handle this revocation. It used to be the local law enforcement where the respondent was at, but now it's any law enforcement, so expanding that. I am just not as familiar with 941 yet, but this is also an area that we've been paying attention to because we've been concerned with how courts have been identifying compliance, even when the respondent is clearly not being compliant or is not compliant. So hopefully I will become more familiar with this. Our program will become more familiar with some of the statutory updates around weapon surrender and can support you. I think a really great resource is within the King County Prosecutor's Office. Their firearms unit has been a really great resource for us for technical assistance related to firearms surrender and weapon surrender. So if anybody has questions, I'm also happy to provide their contact information. Sandra Shanahan is my go-to person, and I think for a lot of people in the state of Washington, the go-to person for technical assistance around weapon surrender. Another aspect related to weapons surrender, when when a firearm is surrendered and returned to the lawful owner, who is not the respondent, the court is now required to advise that lawful owner of the penalty of failing to safely store the firearm. And the whole idea is to also make sure that the lawful owner is now aware of the fact that the respondent should not have access to firearms. And to help ensure compliance, there are kind of 3 additional points that I want to highlight, which is the fact that courts really need to make sure forms are available to petitioners to submit information and a response related to respondents' declarations when they talk about being in compliance, because we've seen where maybe the petitioner got the protection order but didn't show up at the compliance hearing because it's not required. And then the respondent makes a different kind of presentation. And so making sure petitioners are able to provide additional information to ensure that the courts are updated or have the full information related to weapons. For all types of weapon surrender and ERPO hearings, staff from the prosecutor's office may appear and provide information, essentially as a friend of the court, to the court around compliance, because we know the prosecutor's office often has more access in some ways than maybe a petitioner might related to a respondent's history related to weapon surrender and firearms. And then bullet 3 is to help address like the possible Fifth Amendment concerns by providing for immunity from prosecution related to those firearms, dangerous weapons, or concealed pistol licenses that are timely surrendered to law enforcement in compliance with the weapon surrender order or ERPOs. And if the respondent is not truthful in their written submittals or in their testimony, or has not fully complied with the court's order, then there's no immunity. Okay, and I know I'm spending a lot of time on this, but this is sort of an area that has not been consistent in enforcement previously, and this is one reason why the statute, quite a bit of the statute is around weapon surrender. And for anybody who's working on DV cases, stalking, even sexual assault protection order cases, if you haven't been involved before, I think you may be seeing more compliance hearings. You may end up being more involved in compliance hearings. And so we just want to make sure that you're familiar with this aspect of the statute. So some other provisions related to firearms: if the order is entered in open court and the respondent appears in person, further service is not required. And RCW 941 is amended to reference former protection order statutes and pay attention to under the former RCWs what was related to accessing firearms. So with ERPOs, the extreme risk protection orders, the court may permit ERPO records to be sealed if the order is based solely on threats of self-harm by a respondent or a respondent under age 18. So this is obviously recognizing sometimes, not always, but sometimes there is a mental health aspect and wanting to make sure that respondents who just need support around mental health have a way of sealing and protecting the record related to mental health issues. And this is by the respondent where the threats are solely around self-harm, or if the respondent is under the age of 18 and there's full compliance and there are no other active orders. So there is some language in 7105 around what is required related to sealing records involving weapon surrender and ERPOs. So this is very, very text heavy. So just so you know, this is the last slide related to ERPOs and firearm surrender. So this, I'm not going to read through all of this, but basically these provisions were in existing law and are being highlighted here now about the existing ERPO law and law enforcement's involvement. And we're just highlighting it here now because this wasn't well known before. So this is not new law. This was existing law from the previous statute that is now still a part of 7105. And because this PowerPoint is so text heavy, for any of you who know me, you know I like putting a little videos, visual things in. We're just doing a little visual break. And during this, I just want to highlight that this is a new statute. A lot of this is very familiar, related to kind of the standard of evidence, or the standard that needs to be met, the types of evidence that help get a protection order, the kind of information petitioners need, things like that. But the fact is that it is a new statute, and there's also a lot of new information in there. And one thing we know in Washington, jurisdiction to jurisdiction, courts have not been consistent in how they've interpreted or applied the protection order statutes. So this is also an opportunity for any of you who are working with survivors, who are in court observing these hearings, to be tracking information about what is or is not working. Sometimes systems are really, really hard to move, even with legislative changes. And we know which commissioners and which judges understand trauma, understand gender-based violence. And we also know that there are also some judicial officers who are very dismissive, and being able to track information and share information lets us at SVLC and other providers and legislators also know where improvements are still needed. So please be paying attention. The other thing is just a reminder, forms are being developed, e-filing systems are being implemented. And so these are also things to be paying attention to, because that is the whole purpose of the statute. One of the big intents behind the statute is accessibility, and we want to make sure jurisdictions are following through on those statutory requirements. The Gender and Justice Commission and their 1320 work group has been really involved in making recommendations about best practices, and they are now creating a resource page. I don't think it will be up by the time we send out our recordings, but there is supposed to be a resource page both for judicial officers and pro se litigants that has like scripts that will have other resources and information that will hopefully make more sense and make the process more accessible for all parties. And the fourth thing during this visual break that I want to ask is, let us know what kind of future trainings that might be helpful to you related to 7105. Do you need a training on course of control? Do you need a training on parallel criminal civil proceedings and how to apply the Olympic factors, which we're going to discuss in a few minutes? We just did this really quick cover of the firearm surrender, weapon surrender aspect of the statute, but really there's just so much more. And I would like to know, what are you wanting and what are you needing? And we can make sure our future trainings address some of that. Okay, so next is reissuances and renewals, which is something we had not covered before. So all prior statutes had provisions authorizing reissuances of temporary orders. But now under 7105, it's more consistent and clear for parties and courts. So courts must apply a rebuttable presumption against delay when considering a respondent's request for a stay or a continuance based upon a parallel criminal investigation or prosecution, and give due recognition to the purpose of the statute, which is that petitioner should have quick and effective relief. And so the court is supposed to be considering the 8 factors that was first laid out in Olympic Pipeline, and then under Smith v. Smith now is applicable to protection orders. And so just so you know what those 8 factors are that courts should be paying attention to and considering are, what are the Fifth Amendment considerations? Are they even implicated in a case? And so what I mean by that is there a police investigation currently occurring? Are there charges currently pending? Or maybe the prosecutor has declined to file charges, so there's no prosecution consideration. So what are the respondents' Fifth Amendment considerations? Similarities between the civil and criminal case. This is, is it based on the same conduct? Is there more that maybe the civil case is covering that the criminal case isn't covering? The status of the criminal case, how close is it to trial? Is it just at the point of investigation? The petitioner's interest in proceeding expeditiously with the protection order, and the types of prejudices and risks a petitioner may experience with delays, the burden on the respondent, and that might be imposed by the proceeding, the convenience and for the court in managing its cases instead of having to continue the same protection order over and over again for a criminal proceeding. Third party interest. This is parties who are not involved in the protection order proceeding, but may have an interest in the case itself. And then of course, the interest of the public in pending civil and criminal litigation. So the Smith factors are something that the court should now be addressing if there is a request for a continuance related to a criminal proceeding, and the court we've started seeing courts already address this on the record, and hopefully by paying attention to these factors, it gives you time to also make your arguments why a case should or should not be continued. Related to renewals and reissuances, temporary orders to surrenders are also now issued and must be automatically reissued when temporary protection orders are reissued. And before, a petitioner sort of had the burden about always having their LEIS form available, and now this information should be available consistently, where the petitioner doesn't have to continue coming in with a new LEIS form. The clerk is also supposed to be forwarding information to law enforcement related to the respondent's information form, so that law enforcement is getting information from the respondent when trying to serve them about any other ways to be in contact with the respondent. Related to renewals, if the court grants a protection order for a fixed period of time, a petitioner wants to renew the protection order before it expires, they can file a motion to renew anytime before it expires, anytime 90 days, within 90 days before it expires. And a petitioner must state their reason for a renewal, and upon the receipt of the motion to renew, the court will order a hearing, schedule a hearing that will not be later than 14 days from the date of the order. And again, service must be within 5 judicial days of the hearing, similar to when a petition is first initially filed. With the renewal, the petitioner's burden is requires that they include any request for modification from the original order in the motion and statement. And then there's actually no burden to prove current reasonable fear of harm by the respondent. This is something we had seen happen quite a bit in court, where petitioners would have to come back and re-litigate and have to prove that they continue to fear the respondent and continue to fear harm. And that was actually not a burden that the petitioners were supposed to prove, yet somehow we kept seeing this happen in court. And now the statute makes it very clear that the petitioner does not have to prove fear of reasonable harm, continued fear of reasonable harm. The respondent also has some requirements. In this case, the respondent actually has the burden. So the burden shifts from the petitioner to the respondent to prove by a preponderance that there has been substantial change in circumstances and that the respondent will not resume the prohibited acts if the order expires. So the substantial changes, there's quite actually a bit related to substantial changes. I'm not going to go through all the factors that the court considers, but that's in 7105 clearly laid out. The statutes, all the different statutes, actually, not all of them were consistent in explaining with the renewal process the respondent's burden. So this is basically taking the language from the DVPO and SAPO and making it clearly consistent throughout all protection orders, that when a renewal is requested, that the burden now shifts to the respondent. The court actually has quite a bit that they also must do. So the court must grant them a motion for renewal unless the respondent meets their burden. So the default should be that the petitioner should be able to keep the petition or the order in place unless the respondent is able to prove by a preponderance that there's been a substantial change and that they're not going to resume their acts of harm. And if there is a denial, the court needs to put it in writing. The court can consider, they must consider circumstances surrounding a respondent's age at the time of the initial conduct if the respondent was under age 18. So these are some discretionary things for the court to consider. The statutory factors relate to substantial change, whether to renew the order on the basis that the court may renew the order on the basis of the petitioner's motion and statement of the reason for. Okay, sorry, that was a confusing sentence. So renewing the order based on the renewal being uncontested, and if there's no modification being sought, issue a renewal for no less than 1 year and up to a permanent order, which clearly says setting it for 99 years out, and also renewing an order that includes a respondent's children for more than 1 year. So before that was limited to 1 year at a time, but the court now has discretion to renew it for longer. The court also has the discretion to award costs and fees to the petitioner. Court cannot deny a motion to renew for a couple of reasons. First, just because a respondent hasn't violated an order, that is not a basis to deny a renewal request. If anything, that shows that the order is working, and the court should not use that basis to then say the petitioner cannot stay protected. The court should not deny solely because of the age of a party. We've seen this often where courts are really dismissive of sexual assault and DV that occurs with youth under the age of 18, and they chalk it up to like childish behavior when it's actually very harmful and problematic. Just because a petitioner didn't report to law enforcement, that's not a basis to deny an order. Just because there's a no contact order, restraining order in some other case, that is not a reason to deny this. That is not a reason to deny a protection order. Just because there might be relief available through some other case, maybe they could file for a restraining order through a family law case, or because they could ask for a pretrial no contact order through a criminal case, that doesn't mean that the court should deny the civil protection order. Passage of time, this is something we've always known from case law, but has never clearly been in the statute before. But the passage of time is not a reason to deny a protection order renewal. And because the respondent has maybe moved away is also no longer a reason to deny a renewal. Okay, so we have 6 minutes left. Let me try to actually put the CLE form survey. It's too much for me to try to do all of this together, but let me try to put it in the chat. And I will also be sending this survey out with our PowerPoint and recordings. But just a reminder, this is how you will get your CLE credits for any attorneys who are attending. Okay, going into violations and enforcement. So most of the protection orders, the violations, there are criminal penalties based on the seriousness of the conduct related to the protection order. For anti-harassment, only violations of certain provisions will now trigger a criminal penalty for adult respondents, and remedial sanctions of commitment to juvenile detention of up to 7 days for minor respondents. So anti-harassment protection orders, the violations are slightly different than the DV sexual assault stalking protection orders. For ERPOs, the terms access or attempts to purchase or receive have been addressed under the statute to address these violations where a respondent has been attempting to purchase a firearm or is then trying to argue later on that they were not in possession yet. So I'm not going to go too much more since we're at 5 minutes, but I'm happy to talk more about violations and enforcement. One thing we wanted to identify were there are some civil enforcement mechanisms to be paying attention to, and that there are some criminal enforcement mechanisms to be paying attention to. The court must advise the petitioner that the respondent may not be subjected to penalties under the law for a violation of the order unless the respondent knows of the order. And a lot of these violations are based on existing DV statute. There are also several provisions regarding law enforcement, such as when a law enforcement officer investigates a report of an alleged violation of a protection order under this statute, the officer must attempt to determine whether the respondent knew of the existing order. If the law enforcement officer determines the respondent did not or probably did not know about the protection order and the officer is provided a current copy of the order, the officer must serve the respondent with the order. If the respondent is not present, the officer must make reasonable efforts to serve a copy of the order on the respondent. So there's also more responsibility on law enforcement to actually follow through on investigation and enforcement related to violations of the protection order statute, the new protection order statute. And the last thing is modification and termination. So I think with this, I'll just say consistent standards are now across the board related to protection order proceedings. A respondent can, in a 12-month period, each year of a protection order, a respondent gets one chance to file a motion to modify or terminate. And this is to try to curb some abusive litigation so respondents aren't continually coming back and trying to modify and terminate. And then all modifications and terminations must be based on written materials. This is also to cut down on parties having to come back to court over and over again. And the court is required to set a hearing. Again, for modifications and terminations, the respondent basically has the burden of proving by preponderance what has changed that should allow for the modification or the termination. And the factors are laid out. With termination of ERPOs, the extreme risk protection orders, again, it can be requested once every 12-month period. Similarly to regular protection orders, it should be set no sooner than 14 days, no later than 30 days. And in this case, the respondent has the burden of proving that they no longer pose a significant danger to self or others by having access to weapons. For vulnerable adults, the court actually may consider a motion at any time. This is like an exception, and the court shall grant relief consistent with the VAPO requirements related to protecting a vulnerable adult. Okay, 1 minute left. The last point I wanted to make that I think a lot of us are super, super excited about is that the statute actually mandates judicial training now. We have seen some amazing judges and commissioners on these calendars. We've also seen some really problematic judges and commissioners and pro tems who have no idea about the dynamics of domestic violence or stalking or protection order or sexual assault. And so now this statute mandates ongoing training. The training has to be ongoing about best practices related to research on trauma and legislation as it continues to evolve, and that these methods of training are going to be administered by the administrative office of the courts and are not only focused on just judges or just court commissioners who are permanently hearing these, but also pro tems, and need to be updated by the court administrator and presiding judges, the presiding judge, to ensure that the training is ongoing. So I just wanted to end with that. And here's our contact information. I'm sorry, there was not really opportunities to answer any questions. I saw Sandra was answering some questions in chat. Thank you, Sandra, for doing that. And we're excited about the access. We're hoping also for any pro bono attorneys out there who are wanting to work with survivors, like this is some exciting new laws that Washington is pretty cutting edge about. And we would love for you to, help all of us. Our program, King County Bar Association, the volunteer lawyer programs around the state, Northwest Justice Project, we alone cannot be representing survivors who cannot afford an attorney. And so we're hoping also volunteers might be interested in providing pro bono services. And with that, thank you so much. Thank you for your patience. Sorry for so much information, but it's really good information. It's exciting stuff. And we will be sending this out in the next couple of days. So don't hesitate to reach out with any questions and have a good day. Thank you.